Gov. He is a CAR and a longtime attorney with CAR. I'm Jody Souza. I'm your education and event manager here at SCORE. So if you have any questions, go ahead and put those into the Q&A box. Gov and I will be monitoring that throughout. As he talks about different things and links and whatnot, I'll do my very best to get those up as soon as I can into the chat box. We are recording this, so give us a couple days. We'll get it, the beginning, all of this cut out and all of that kind of stuff, and we'll send it out in case you want to listen again. But again, any questions, go ahead and put those in a Q&A. We'll kind of answer them as we go, or we'll leave some to the end. So without further ado, Gov, what's going on in the housing world?
In the legal housing world.
Yes, right.
Yeah. Hi, everyone. Good morning. Good to see you. I'll say I come here twice a year. Unfortunately, it looks like it's virtual right now, but you never know about the fall. You never know. Things will probably be changing. So, which of course is probably the first thing you want to know. What's changing? Has anything changed? And I'll give you an update on that first, and then I'll talk about all the other new stuff. And the quick answer is, you know, the governor says June 15th, everything's opening up. So everyone in real estate says, well, how does that affect real estate? And the answer is, honestly, we don't know yet. You know how you move into these, you know, orange tier, purple tier, red tier, orange, you know, yellow tier. Those tiers have nothing to do with the real estate laws, by the way. And as far as June 15th, what the governor's talking about, that's also not directly related to real estate. In other words, the real estate rules are separate and they're still in place. And we are lobbying very hard to get them changed, because logically, you know, if movie theater, I don't know where you guys are, but here movie theaters are open and indoor dining is open and all these things are open with respect to other businesses. So what's up with real estate? Logically, the rules on real estate should be changing also, as far as showing rules, as far as open house rules, etc. Okay, so we're pushing for that. I'm pretty sure, I'm almost totally sure that things are going to change. I mean, you can't just have one sector of the economy having it, you know, being closed as much as it has been, and everything else opening up. But the point is, I don't have details for you yet. So you have to be patient, you have to be flexible, you have to keep on doing what you've been doing since last July, really, is when these rules have been in place. So that's all I can tell you. Just stay tuned, okay? If you have specific questions on things, please put them in the Q&A. I can see there's already questions in the Q&A. Yeah, I'll get to all your questions. But as far as the big picture of COVID rule changes, nothing has changed yet. There is one new COVID thing this year, which is the fact that if you have a work site, you know what that means? That means that could be an office, could be a real estate office. If you have a work site and someone at your work site tests positive for COVID, you have an obligation by the next business day to notify in writing everyone else at the work site who may have been in contact at the work site with the infected person during their infectious period. So if we're talking about a real estate office, we're talking about the broker's responsibility. What this means, if someone works at the office and they tell you, oh, guess what? I just tested positive. You have to figure out, okay, the infectious period is considered 2 days before they tested positive to 10 days after. So the person who was sick, were they in the office any of those days? And who else was in the office during those days? You know what I mean? And you have to tell in writing everyone who was in the office during this time period. What do you got to tell them? Well, we have the law is called SB 685. We have a Q&A on our website that sort of explains, I'm sorry, AB 685, notification to employees. And the Q&A we have on this will also tell you exactly what you need to put in this written communication. It could be an email to your people. And it's different if you have your employees versus independent contractors. Because if you have actual employees working for you, not realtor independent contractors, you actually have to inform them about their rights under California law. Okay. So, like I said, I hope this goes away too, right? I mean, we hope this brand new law goes away when everything else goes away, as far as, the showing rules. But maybe people testing positive in the office, maybe that's going to stay around for a while. Thank you, Jody, for putting that stuff up there. Okay, so that's the only really new thing on COVID. Before I go any further, Timothy Yee asked me if there's still open houses going on. Who's responsible for enforcement and or penalties? Exactly. I mean, they haven't changed the rules on open houses, but people are doing them anyway. That's not fair. Well, who's in charge of enforcing that? Well, that's a very interesting question. It can be enforced at many levels. The California Department of Public Health considers that a violation. The Department of Real Estate considers that a violation. It's actually a criminal misdemeanor to do this. So theoretically, local law enforcement, some places, I don't know about your area, but some places I do know local law enforcement, I've seen them breaking up open houses. And to me, what the biggest incentive to comply with these rules are? Let's say you or your seller, does this open house in violation of the rules, and somebody who attends the open house claims that they got sick because of the open house. And there were people at the open house there were too many people there. It wasn't just one buying party. And it was a super spreader event. And, I was there and they weren't taking precautions and I got sick. So I'm going to sue the seller. I'm going to sue the listing agent because I got sick because they weren't following the rules. I know what you're thinking. How do you prove that that's exactly where they got sick? And bottom line is, courts have been imposing liability without requiring that absolute proof that someone actually got sick at this location. So I think there are many reasons why people shouldn't violate these rules, but it's also a good point that, people are still doing them and you don't seem to be seeing much enforcement. So that's all I can tell you at this point. Anyway, let's talk about new laws that have nothing to do with, or not all of them have something to do with COVID. Okay, let's talk about new laws and new forms everyone needs to know about. And that will get me I'll definitely answer your questions, Margaret, because they're relevant to one of these new laws I'm about to talk about. The first new law I think I want to talk about is there's a new disclosure form. All right. There hasn't been a new disclosure form in California for about 15 years. For the last 15 years, if someone asked me, I got a listing, what are the disclosure forms I have to worry about? For the last 10 or 15 years, I would have said, well, you order an NHD report, and then there are 4 other things you think about: the TDS, the seller property questionnaire, the lead paint form, and the booklets, right? The disclosure booklets, earthquake, environmental hazards, home energy, and lead paint. Well, now if somebody asks me, instead of saying NHD plus 4, I'm going to say NHD plus 5, because there's a new form, the HHDA, the Home Fire Hardening Disclosure and Advisor. And this is just like the TDS. It's not, if it's a 1 to 4, you got to do it. Not required in probate, REO, bankruptcy, not required in a trust sale if the trustee unless the trustee used to be on title or lived in the property in the last 12 months. All right. What's different about this law compared to the other disclosure laws is that it's not required on every deal. It's only required if the property that you have listed is in a very high or high fire hazard zone and it was built before 2010. All right, which means every time you take a listing now of residential 1 to 4, you have to figure out 2 things. Is this property in a fire zone and when was it built? Because they're both relevant. So the first thing is fire zone. You and I who live in California, there's 4 possibilities. Either you're not in a fire zone, you're in a moderate fire zone, you're in a high fire zone, or you're in a very high. This form is only required if you're in the last 2, high or very high. If you're in a moderate or no zone at all, like me in Culver City, the form is never required. Even if you are in one of those zones, the high or very high, the form is only required if the house is built before 2010. So first thing, how do I figure out what zone my listing is in? Well, very simple. You go to your NHD report. Now your NHD report lists 2 earthquake zones, 2 fire zones, 2 flood zones. What are the 2 fire zones on the NHD form? Well, one is very high fire zone, which is exactly one of the ones that triggers this disclosure. The other zone on the NHD standard report is called wildland fire areas subject to substantial forest fire risk. Okay, so if you're NHD, if neither box is checked, you're not in a fire zone, form not required. If the very high fire zone box is checked, you're in a zone. If it's pre-2010, you need the form. But what if that box isn't checked, but the wildland fire area box is checked? Well, you know what that means? That means you're either in a moderate or a high zone. So you say to me, yeah, but I thought I only need to do the form if I'm in a high, not a moderate. So I need to figure out which one I'm in, right? And the answer, yes, right. Well, how do I find out if I'm in a moderate or a high? Well, you have to just dig a little deeper, which means talking to your NHD rep. They can tell you if you're in a moderate or a high, okay? So in other words, you may have to go that extra step. By the way, some offices, some companies have taken the position that if we're in any type of fire zone, we're going to provide this form. And there's nothing wrong with that at all. But if you only want to provide the disclosure form when you actually have to, then if the NHD says wildland fire area, you're going to have to do a little more investigation to see if it's moderate or high. And like I said, the investigation I'm talking about is talking to your NHD person who will be able to tell you. Okay? All right. So now we figured out I'm in a fire zone. The idea is if you're selling a house to a buyer in a very high or high fire zone, you're telling the buyer, hey, buyer, you know, this house you're about to buy is in an area where they have wildfires. So you might want to think about hardening your home, which means taking steps to make it more fire safe, less vulnerable to fire damage. Now, if the house was built after 2010, it was built under the new fire building code, which means in a very high or high fire zone, it has to be built a certain way, meaning dual pane windows, no wood roof, no combustible landscaping within 5 feet of the house, no gutter covers of combustible material, etc. So if you're buying a house built after 2010, you're already buying a house that's as fire safe as it can be, pretty much. So the seller doesn't have to tell you anything. But if you're buying a house in a pre-2010 that was in this very high or high fire zone, that means even though you're in a sort of a dangerous place, the house isn't necessarily as fire safe as it could be. which is why the seller then has to provide this form to the buyer saying, hey, number one, you're in a fire zone. Number two, you might want to think about fire hardening. And then you have to disclose right on the form. The seller has to answer 6 questions, right? They got to tell the buyer if they have a wood roof, or if they only have single pane windows, or if they have combustible landscaping within 5 feet of the property, etc. So, in other words, you're telling the buyer this house isn't as safe as it could be. And the buyer may say, well, I'm glad you told me that. I don't want to buy your house unless you have to, in other words, you have to change those windows out. And the seller can say, no, I don't. I don't have to do anything. You want to buy my house? Buy my house. You don't want to buy it? Don't buy it. But I'm not obligated to change out the windows or the roof or anything like that. All I have to do is disclose to you the situation, then you decide what to do. Okay, so it's not a mandatory upgrade. It's simply a mandatory disclosure. Okay. And then the third thing on this form that's causing some confusion, it refers to home fire hardening final inspection report. It says, if checked, seller has obtained a final inspection report, must be provided to the buyer. So realtors have been asking me, does that mean every time I sell a house in a fire zone, we got to hire someone to do a home hardening inspection report? The answer is definitely no. The only time that report's going to come up is if the seller already happens to have one in their possession. They have to give it to the buyer. And you know what? These are not inspection reports done by private inspectors. These are government reports. So if the seller happens to have in their possession a government issued fire hardening inspection report, all this form says is give it to the buyer. Pretty simple. By the way, which sellers are going to have these reports? Basically, let's say you're a builder, or you actually had a pre-2010 house and you did a major renovation. And the local building authority said, well, to do this renovation, to get the permit for this renovation, you also have to agree to do these fire hardening steps. And once they did them, they got a final inspection report saying, good job, you did it. So it's only those sellers who are in that position who are typically going to have this final inspection report, right? And that's when that's going to be relevant. Okay, so that's this new law. And just as I got through telling you about this new law, which is brand new, there's going to be another law July 1st that's related to this. This is dealing with fire hardening. The law coming up July 1st deals with defensible space, okay? The new law July 1st says, basically, when you're selling a house, the seller is going to have to, okay, if the area where the seller is selling requires compliance with a defensible space rule, then starting in July, the seller is going to have to disclose to the buyer that do they have documentation that they are in compliance with this local law. Or the buyer and seller can agree that the seller is not in compliance, and the buyer agrees that within 1 year after close, they will bring the property into compliance with the local defensible space rule. Or there's some local ordinances that say, nope, seller, it's absolutely your responsibility. You can't pass it off to the buyer. So obviously we need a new form to explain this. Well, guess what? The forms committee decided that instead of coming up with a new defensible space form, they're going to put what I just said onto this new home hardening form. So the home hardening form that just came out January 1st is already going to be tweaked July 1st. So it's not just going to be the fire hardening form, it's going to be the fire hardening and defensible space form. See what I'm saying? I don't think they've totally finished the final language yet, but they should pretty soon. The form will come out end of June, and it'll be required July 1st. So sellers will be able to comply with two laws at the same time on the same form. Okay? So even though this is a brand new form you just got used to, it's already going to be changed a little bit. It's going to have a new section on defensible space where the seller's either going to say, yes, I'm in compliance, or buyer, you agree that you're going to bring it into compliance within a year after close. And obviously the buyer and seller are going to negotiate that issue, right? Okay. All right.
We've got two questions on that. I figure if we want to ask those ones.
Good idea.
What about local fire zones?
Yeah. And that's a good question. Local laws are local laws. So the NHD report doesn't necessarily cover local laws. Some do, some don't. They're not required to under state law. And this home fire hardening form isn't related to local fire zones either. On the other hand, if I'm a seller and I'm aware that maybe the property I'm selling isn't in one of these state very high or high zones, but I just happen to know as a seller that my property is in a local fire zone, that's a material fact that I'm aware of. And I think that seller needs to disclose that. Okay. So yeah, that's a good question. And Sandra defined defensible space, great idea. I'm not crystal clear. It basically means you don't have vegetation within X number of feet from your house. Obviously, that's to prevent damage to the house in a fire. So if there's no combustible vegetation within 100 feet of the house, it's less likely that the house is going to catch on fire. Oh, we all know about flying embers and everything, but nevertheless, that's what it means. Christina, how does the seller show proof of compliance? I'm assuming you mean the defensible space rule. They don't really have to. They just have to swear to God that they're in compliance, right? I'm sure there is going to be, depending on where you are. I don't know about San Jose, Santa Clara County. I'm sure there are documents you'll be able to have showing that you're in compliance. But the bottom line is the seller's just going to have to state that they're in compliance, okay? Unless a local law requires more than that. All right, good questions. You're going to keep asking them. I'll keep getting them, but let me go on.
Yep. And then I just want to remind, I see somebody has their hand raised, but please put your question in the Q&A for us so we can get it. Just click that Q&A button at the bottom and type in your question.
Yeah, and I think we'll have time at the end if you want to just raise your hand and ask questions. But let me cover what I want to cover first. Okay, good questions. I'll keep going. New law number 2 that everybody should know about is Prop 19, which just took effect April 1st. But it's more complicated than that. Here's the bottom line. Normally, as you know, we got this thing called Prop 13, which means you buy a house and your property tax is based on the value of the property, which is basically determined by what you paid for. But so your property tax is based on that. But then each year, even as your property goes up in value, your property tax stays roughly the same. Doesn't go up much at all. That's Prop 13. You don't get new higher property taxes. That only happens when property changes ownership. But when it changes ownership, that's when it gets reassessed and your property taxes go up. Okay, we all understand that. There are some exceptions, though. There are some situations where you can buy a new house and it doesn't get reassessed at the current fair market value, what you paid for it. In other words, there's this law, there are a couple of laws. One is called Prop 60, Prop 90, which says if you're over 55 or severely disabled, you can sell your current house, which you bought a long time ago, so your property taxes are pretty low, even though it's now gone up in value. You can sell that house if you're over 55 or severely disabled, buy another house of lesser value, and transfer the low property tax you've been paying on your existing home to the new home. Let's say you bought a house a long time ago for 200,000. It's now worth $1 million. You're over 55 or disabled. You can sell your $1 million house and buy, let's say, a $900,000 house. And you can transfer the low property tax you've been paying based on your 200,000 that you paid for it to this $900,000 house, and you're paying property taxes on a $900,000 house based on your 200,000. That's the law. That's been the law for 30 years. Of course, the restrictions on that are you have to buy a cheaper house, and you can only do this once in your life, and you have to stay within the same county. Or there are like 10 counties in California where you can move from one county to another. I believe Alameda County is one of those. I'm not sure about Santa Clara County, but I'm sure in other words, if you sell in San Jose, you can move to Alameda County and take your property tax with you one time if the new house is cheaper than the old house. Well, here's Prop 19 expands that. Prop 19 says, if you're over 55, severely disabled, or a victim of a wildfire, no matter how old you are, if you're disabled or not, you can take your low property tax you're paying on your existing house, and you can move anywhere in California, anywhere, and take that property tax with you. And you can buy a more expensive house. And you can do this 3 times rather than 1 time. And even if you've already done it once under Prop 60, Prop 90, you can do it 3 more times. Now, what if you buy a more expensive house? Well, in that case, there's a slight adjustment. I'll give you an example. Let's go back to my example. You bought your own house a long time ago for 200. It's now worth $1 million. You want to move and buy a house for 1.1 million. You want to sell your $1 million house and buy a 1.1. You're over 55, or you're disabled, or you're a victim of a wildfire. So you do this. You sell your $1 million house that you're still paying property tax based on 200, and you buy a 1.1. What is your property tax basis going to be on that new 1.1 million house? You know what it's going to be? It's going to be 300,000. You're going to take the 200,000, and then you're going to add to that the difference between the purchase price of the new one and the sales price of the old one, which in my example was 100,000. Add that to the 200. So your property tax basis on the new home is going to be 300 rather than 1.1 million, which is a big difference. So the idea of this law is to encourage people like seniors, well, not necessarily over 55. I don't think is a senior. I say that because I'm over 55. I don't consider myself a senior. Anyway, bottom line is, it says if you're over 55, like this affects me exactly. I bought my property a long time ago in Culver City. It's gone way up in value. But now, thanks to this law, I can sell that Culver City house and buy another house anywhere in California and pretty much take my low property tax I've been paying to the new one, even if the new one's more expensive. So the idea is that people who are hesitating to move for property tax reasons shouldn't hesitate anymore. That shouldn't be something that's stopping you from moving, which is a good thing. Now, of course, there's a negative aspect to Prop 19, which was actually going to happen anyway, so it's not really Prop 19's fault, and that is they've reduced the exemption from property tax reassessment for properties for intergenerational transfers. For about 30 years, there's been another exception to the reassessment upon transfer of property. For the last 30 years or so, if you transfer your primary residence to your child or grandchild, that didn't trigger reassessment. Plus, you could transfer an additional $1 million worth of real estate to your heir without reassessment. Well, that's gone. Well, the extra $1 million is gone. Now the only thing you can transfer to your kids without triggering reassessment is your primary. And that only works if the recipient uses it as their primary. And if they use it for their primary for 10 years, that's great, no reassessment. 10 years from now, they decide to sell it, to rent it out or something, it's going to get reassessed. So obviously that's a negative, but I'm telling you, even before Prop 19, there was strong movement in California legislature to get rid of the intergenerational transfer exemption from property tax reassessment. If you look at it that way, at least Prop 19 preserved the transfer of primary residence to an heir as long as it doesn't, as long as it's continued to use as a primary. Okay. By the way, one more thing about Prop 19, which is good. So the law took effect April 1st. But what about someone who sold their house, over 55, disabled? Let's say they sold their house and closed back in February or January, last November, or last September. But they didn't buy a new one yet. So they did one part of this, one leg of this transfer before April 1st, but they haven't bought the replacement yet. When they buy the replacement after April 1st, can they transfer the low property tax that they had on the original property, even though they sold that property prior to April 1st? Remember, obviously, if you're in the same county and the purchase price of the new one is less, absolutely, for sure, you can do it. But let's say they sold their existing property prior to April 1st, but now they want to buy a new one, either outside of this county in Alameda, or they want to buy a more expensive property. Can they transfer their low property tax basis on the former property to the new one? And the answer is apparently yes. Why do I say apparently? The Board of Equalization basically said that's the case. Many assessors that I've run into are doing that. And even if there's some I don't know about your assessor, even if there's any assessors who aren't doing that, there's a California law being proposed that looks like it's going to pass that would basically require all the assessors to do that. So basically, looks like you can take advantage of Prop 19 even if you sold the sale leg prior to April 1st. And remember, you got 2 years to do the second transaction. You sell your one property, you got 2 years to buy another one in order to transfer that property tax base. Okay. And guess what? You can actually buy the replacement before you sell the original, as long as you do them both within a 2-year period. Okay. All right. Let me see if there are questions on that particular thing.
There are several.
Yeah, let me look at it. All right. Mary, can parents sell a property to their children at a price lower than the marketing value? There's a good question. But remember, an intergenerational transfer, I mean, there are two issues here. First of all, if the child uses it as their primary, there's no reassessment. I think what you're asking is, they're not going to use it as a primary. Can the parent sell it at less than fair market value, so that that lowers the child's property tax? They could, but remember, the assessor has the ability to say, no, the sales price was less than fair market value, so we're going to assess it at higher than the sales price, right? So that's always a possibility. Suzanne, you're still trying to get your head around what plants are combustible. That's a good question. I don't know myself. We need some more guidance on that. You're exactly right. We need definite, I think before July 1st, we're going to have more definitions of what this means. And right, it's relevant right now, right? Because you have to disclose if you have combustible vegetation within 5 feet of the house. What does that mean? Grass? Is grass considered vegetation? Does it have to be cement? Don't know the answer. We're trying to get the answer. Sandra, isn't it true that the replacement house is less than 1 million, but more than the original home? Yeah, there are some details here. Remember, what we're talking about is transfer of primary residence still is exempt from reassessment if the recipient uses it as that. But you're right. If it's more than $1 million over the assessed value, there is still an adjustment to the property tax. I'm not going to give numerical examples. And you and me are not supposed to be giving tax advice to our clients anyway on the specifics of this. You, because you're not a lawyer, me, because I'm not a tax lawyer. But you're absolutely right. If the replacement property on this intergenerational transfer is more than $1 million over the value of the first one, there is an adjustment. Now, I think that's what you're getting at. Randy, yes, it can still happen with grandchildren. But remember, people get shocked by this, but it's always been the law for 30 years. The grandparent to grandchild transfer only works if the parent is no longer alive. You can't bypass the kid if the kid is still alive. Okay, so these transferring the primary residence and being exempt, it can be parent to child or grandparent to grandchild if the parent is no longer alive. Okay. Alex and Mercedes, none of this changes if the property's in a living trust or not. The same exact rules apply. Okay. Angie, you're getting a little complicated here. If the property tax 1%, move to yeah, I mean, I'm saying the property tax basis changes. I mean, you can take that with you, but if the county you're moving in has a higher property tax, yeah, that higher rate will be imposed on this basis. So you take your basis with you, but you don't take the county tax rate with you, right? Good question. Very good question. By the way, what do you need to do to get the benefits of Prop 19? Remember, the benefit is that you're taking your property tax from your old property and moving it to the new property. This doesn't happen automatically. When you buy the replacement property and you want to transfer, you have to go to the county assessor's office and fill out a form. That's what you have to do. Okay. Frank, qualified buyer can buy a replacement house first and within 2 years. Yes, buy the replacement house first and within 2 years sell the current house and transfer the tax rate after selling the current house. Is that correct? That is absolutely correct. And that was true under Prop 60, Prop 90. It's true under Prop 19. Mary Kay, remember, now you're getting into capital gains tax as opposed to property tax. In other words, which is why I'm not going to turn this into a tax seminar. When you sell your house, when you're deciding whether to sell your house, you think about not just property taxes, you think about capital gains impact, right? So sometimes it's a good idea to move for property tax purposes, but it's not a good idea to move for capital gains purposes. So that's about all I can tell you for that. You know, your client's got to get tax advice when they make these decisions to get the tax impact of what they're doing. Marissa, Morgan Hill requires certain things. Yeah, local areas probably are more specific, defining what type of vegetation we're talking about. Jordan, there's a rumor that legislature might change the effective date. There's always rumors. I don't pay any attention to them until they happen. Seriously, I honestly don't know that. Jasmine, that's a pretty creative idea that they were 52 when they did this, and now they're over 55 now, so they want to take advantage of something they did several years ago. That's not going to happen. Deborah, what if you transfer half the rental property, transfer to the daughter? Right. I mean, that's still a transfer to the daughter, but that's not a primary residence, right? They're not using it as their primary, I'm assuming. By the way, if you guys have detailed questions like this, you need to call the legal hotline. Married, when I say you have 2 years, does that mean I can go all the way back to 2 years to April 2019? Can I go that far back? That's what we're waiting for legislation to determine. I think the answer is probably going to be yes. Deborah, yeah. You said it's a rental property, or is it? Okay. No, I'm not catching whose question is which. Sandra, yes, Prop 19 applies when it's a living trust. Jasmine, as I said, I'm not optimistic about your particular case. Anyway, I must go on, okay? We can go back to this, but let's talk about some other things too, okay? These are all great questions. So that's obviously a very important line. Kim, yes, you fill out a form at the county assessor's office. You do it, remember what you're trying to do here is transfer the property tax from the old one to the new one. So obviously you're not going to do this until you buy the new one, right? It's no, I mean, you're not transferring anything if you don't have the new one to transfer it into. So obviously you don't do this until you buy the new one, and you can wait till escrow closes. You know, you don't have to do it right away during escrow. You can still take advantage of this after escrow. You don't have to do it during escrow. I'd wait till after escrow, okay? Because you don't own the property yet until it's escrow is closed. All right. All right, I'm really going to go on. These are great questions. Because there's another law that we need to talk about, and there are also questions on that. So the first big law we have is new disclosure on home hardening. And there's going to be also new disclosure law July 1st on defensible space, and those two are going to be combined into one form. Second, we talked about Prop 19, effective date April 1st. Third new law, SB 91. We have a Q&A on this one too, called the Eviction Moratorium Extension and State Rental Assistance Program. All right. What does this law do? For one thing, it extended the state eviction moratorium all the way till July 1st. By the way, the federal government also extended the federal eviction moratorium to July 1st. Where I live, LA County extended their eviction moratorium. I don't keep track anymore. I forget if Santa Clara County or San Jose or Santa Clara have their own eviction moratorium. But I'm just going to talk about the state one. The state one, which is extended to July 1st, says the following. Number one, if someone can't pay the rent because of COVID, you cannot evict them right now. But they still have to pay 25% of the rent. Okay, so I got a tenant, can't pay all the rent because of COVID, but they're not even paying 25%. Can I evict them? You can evict them on July 1st. What if the tenant has a COVID reason they can't pay all the rent, but they are paying the 25%? Can I evict them on July 1st? No. You can never evict them for the back rent that they didn't pay you. Now on July 1st, they have to pay all the rent unless this law gets extended. But for the 75% they weren't paying for the last few months, you can never evict them for not paying that money back. Starting July 1st, though, you can sue them for the back COVID rent. And if they didn't even pay the 25%, you can evict them on July 1st for not paying the 25%. Which leads to the question, I got a tenant not paying the rent. How do I know the reason? How do I know if they have a COVID reason or a not COVID reason? The only way to tell is to try to evict them. You got to give them a pay rent or quit. But you don't send them the normal 3-day notice to pay rent or quit. You send them the COVID pay rent or quit, the PRQ COVID. It's actually the PRQ TP for transition period. When you send the tenant that form, attached to that form is a declaration of COVID financial distress. If the tenant returns that form within 15 days, saying on the form that they swear under penalty of perjury that they do have a COVID reason, COVID loss of income, COVID medical issue, whatever, that makes them unable to pay the rent, then you have to accept that. You can't demand proof. You just accept it, but they still got to pay 25%. Okay. If the tenant does not return that form within 15 days after receiving the notice, you can evict them right now. Now, remember the courts were closed completely for many months? Well, now they're back open, but they're backed up. It varies county to county how backed up the courts are, but they are starting to do evictions now. It's just that it may take longer than it used to at this point. All right. All right. So what about a tenant? It's not a question of paying rent, but they're violating the lease. They are not allowing me to show the property. They're creating a nuisance. They're engaging in criminal activity. They have subtenants they shouldn't have. They have pets they shouldn't have. Can I evict them right now for violating those terms of the lease? The answer generally is yes, unless you're in certain areas. Now, I'm in LA County. LA County's law is so strict, tenants don't have to allow their property to be shown. So you obviously can't evict a tenant for not allowing you to show. In LA County, you can't even evict a tenant right now for having subtenants or for having pets. You can only evict a tenant in LA County right now for damaging the property, creating a nuisance, or criminal activity. Under state law, though, if the tenant's doing anything like that, you can evict them right now. Now, where you are, Santa Clara County, like I said, I no longer try to keep up with every single county's rules. So maybe your county, or maybe the city of San Jose has some restriction like that, that says you can't evict a tenant for not allowing you to show. I don't know. But if your local law doesn't have something like that, then you can evict them right now for violating any of these terms. Okay? Now, what about a tenant, though, where I just want to kick the tenant out because I want to sell the house? It's not a question of them paying me or not. It's not a question of them violating the lease. The question is, I want to sell the house, so I want to kick them out. Can I do that? Once again, there's California law and then there's local law. Under California law, normally, single-family home owners don't need a reason to evict. You don't need a reason. You can just evict. Normally, if you're an owner-occupied duplex, you don't need a reason to evict the other person. Normally, if you have an apartment building newer than 15 years old, you don't need any reason to evict. But in California right now, until July, all residential properties, including single-family, new buildings, duplexes, all California residential properties require just cause to evict the tenant. And remember what I said, just cause means they're not paying rent and they don't have a COVID reason, or they're violating some other term of the lease, or I haven't told you this yet. On what basis can I evict a tenant for no fault? In other words, the tenant's not doing something wrong. I just want to evict them. Is there any basis I can do that? Yeah, there are 4 reasons you can evict a tenant for no fault in California. Number 1, because the owner wants to move in themselves. Owner move-ins are fine. You can move in, your kid, your grandkid, your parent, or your grandparent, or your spouse. This is a simple way to separate from your spouse. Sorry, honey, you got to move into the rental property so we can kick that tenant out. Nothing personal. Just kidding. Just kidding. Anyway, the point is that's a legitimate reason to evict a tenant. Of course, I'm assuming the tenant's month to month. If tenant's on a lease, you can't evict them till the end of the lease. All right. Well, great. How about this? Can I just say to my tenant, I want to move in, kick them out, move in for a week, and then sell the house? No. You have to act in good faith. If you're going to use owner move-in as an excuse to kick out the tenant, that means the owner has to live in there for a period of time, probably at least a year. Okay. Second legitimate way to evict a tenant for no fault in California is the house has been damaged and you need to renovate it because it's not currently habitable. If that's your situation, you can evict the tenant because you got to renovate. You notice I didn't say you can evict a tenant just because you want to renovate to get it ready to sell. You can only evict them for renovation if it's a required renovation for health and safety reasons. Okay, third legitimate reason you can evict a tenant for no fault right now in California is the landlord can simply take the house off the rental market. Landlord can say to the tenant, you know, you got to leave because I'm just not going to rent this property to anybody anymore. And assuming they're month to month, you could do that. But, well, how about this then? That sounds like a good idea. Can I just take the house off the rental market, kick the tenant out, and then a month later put it back on the rental market and sell it or get a new tenant? No. If you use the I'm taking it off the rental market excuse to evict a tenant, the house has to stay off the rental market for at least 2 years, which means you can sell it, but the buyer couldn't rent it out either. Maybe the buyer doesn't care, and maybe that'll work, right? But fortunately for realtors and sellers, there's a fourth legitimate reason why you can evict someone right now. And that is if you have a single family home for sale and you get a buyer and the buyer writes an offer that's accepted, and in the offer, the buyer agrees to move, that they're going to occupy the property. They don't have to commit to a particular period of time, but they do agree they're going to occupy. Once you're in contract with an owner occupying buyer, you can now evict the tenant, assuming it's a month-to-month tenant. Okay, you don't have to pay them relocation or anything. You can just evict them. So that's good. Of course, then there's local laws. Do you know where I live in LA County? You can't do any of these things. No owner move-ins, no renovation, no taking it off the rental market, no I'm selling the house to a buyer. In LA County right now, there are no fault evictions. You tell me if Santa Clara County or San Jose allow no fault evictions. I think they do, and I could look it up for you, but like I said, we don't, there's so many counties and cities in California, we can't keep track of them individually. But I'm telling you what California law is. And California gives you 4 ways to evict a tenant for no fault. Okay? Now, there is good news associated with all of this. First of all, hopefully this is all going to end July 1st. That would be nice. But of course, it might get extended. The federal law, who knows? Even if the California law doesn't get extended, if the federal law gets extended, you won't be able to evict people under federal law. Hopefully this all ends soon. Okay. But the good news from SB 91, and by the way, before I do it, let me just questions relevant to this. So Margaret, duplex, buyer wants to move into one side. Unless San Jose or Santa Clara County has a rule specifically prohibiting owner move-in, then the buyer, the owner of the property can give notice. I mean, the buyer can't give notice until they own the property, right? But the owner of the property, so maybe you'd have to wait till the sale happened. Then the buyer who now owns this duplex wants to move into one side, unless there's a San Jose or Santa Clara County law, like there is in LA counties prohibiting owner move-ins, then they can definitely do that, you know, give them a 60-day notice, assuming that that tenant is not on a lease. Now, Margaret, your other question is a very good question. Okay, can I assume that this law is going to end on July 1st? And since the law, assuming this law ends July 1st, then I can evict a tenant for any reason I want. So I'm going to assume that this law is going to end July 1st, which means 2 months before that, you know, like on May 2nd or something like that, I'm going to give the tenant a 60-day notice, because when July 1st happens, this law is no longer in effect, and I've legitimately given the notice and they have to leave. That's a great question. I think that should be okay, but if I'm conservative, and I always am conservative when I give legal advice, I can just imagine a California judge, when they don't leave on July 1st, the California judge saying, well, you should have waited till July 1st to give that notice, because when you gave that notice, you weren't allowed to give it, even though it didn't take effect until you were allowed to do it. And I hate to tell you, the law is not clear on that point. I mean, obviously, if the law gets extended, that notice means nothing anyway. I'm leaning towards it's okay to do that. I guess the worst case scenario is the judge would make you start again, right, on July 1st when the law goes away. So I guess you're not risking much by giving them the notice prior to July 1st in the hope that this law is not going to get extended any further, right? Good question. And Margaret, you have all of the rental questions today. Not all of them. Okay. No current lease, tenant occupied more than 20 years. Won't allow landlord to show. If you were in LA County, they don't have to let you show. I think Berkeley is the same thing. I think San Francisco has the same thing. But unless San Jose has a specific rule that says tenants don't have to allow you to show, if your 20-year tenant won't allow you to show, that's grounds to evict them right now. Okay, Alex and Mercedes, can the landlord request a COVID test result documentation? Now, I think you're asking for are you asking for current tenants or prospective tenants? I think for current tenants, no, but let's say prospective tenants. Landlord says, I'm applying this uniformly. There are no exceptions. Anyone who wants to rent here needs to have a positive a negative COVID test. Well, you're not discriminating if you require that from everybody as prospective tenants. So I think that's okay with prospective tenants, but I don't think you can ask your current tenants to do that. Okay. Connie, owner lives in the house, wants to evict the tenant so he can sell. Tenant's lease is up this month. So owner lives there and the tenant lives there. I guess you're saying they both live there. Bottom line is this. It doesn't really matter whether the owner lives there or not. If the tenant is on a lease and the lease is up, unfortunately, that in and of itself doesn't give you the ability to evict. They are allowed to convert to month. To evict the tenant right now, at least until July, you need just cause. They're not paying, they're violating a term, owner move-in, selling the property. So yeah, Connie, you can sell the property once you get a buyer in contract. but you can't evict them just because the lease is over. If I think that's what you're getting at. Red Fox, how about an expiring lease? Can I evict the tenant without paying relocation? I am selling it after the tenant is out. In other words, okay. I just got through answering the question that if it's a month-to-month tenant, if the lease ends, you can't kick the tenant out just because it's a lease ending. So you're asking about relocation, but I'm asking on what grounds are you going to kick the tenant out, right? You can't really kick them out until you have a buyer, right? You can't just kick them out because the lease ended. But when you do get this buyer in contract to sell, then you can evict them and you don't have to pay relocation. Jason, seller sold the rental property. The buyer needs to move in, but the tenant refuses to move out. My answer would be, did the seller guarantee in the purchase contract that the property would be vacant at close of escrow? If that's what the seller guaranteed in the contract, then they sort of have the responsibility to kick the tenant out, right? Otherwise, it's buyer's property, now it's their responsibility. Marcus, can we issue a termination of tenancy notice for a lease for a single family home not under rent control for no fault reason? Remember, right now, you need just cause to evict in California. So, I mean, if you're going to give them a termination of tenancy notice, you still need to give them a reason, right? Because remember, the lease automatically turns into a month. If you want to terminate, you need to put the reason in the notice, and I gave you what the reasons are. Katie, I can make sure that Jody has the Q&As. I think she probably has them anyway. Yeah, I mean, when the tenant is saying the COVID excuse to not pay or delay payment, that doesn't affect other just cause. If you have just cause to evict because of selling the house or owner move in or violation of a lease, it doesn't matter if they have a COVID reason to not pay the rent. You're not evicting them for not paying. Now I understand your question, Alex. You had the question of, I think you had the question of demanding COVID test results. Sorry. In other words, tenant not paying rent because of COVID, can I demand a COVID test? The answer is no. Now I understand your question. All right. Section 8 tenants, the rules are the same. The only difference is to evict the Section 8 tenant, you first have to give them notice to terminate the Section 8. But if you have a legitimate reason to evict them, like I've been talking about, you can just evict them. If you want to evict them for no fault, you'd have to first give them a 90-day notice and then the no fault unit. Let me just do a couple more of these and I'll move on. Katie, unit has 2 co-tenants. One moved out, the other stayed, but can only pay 50%. Yes, I mean, they have to pay, even though the one person left still has to pay the entire rent. Just because one of the tenant leaves and the other one can only pay 50%, too bad. Should have had a better roommate, right? Red Fox, can I lease 1 more month after expiring lease and evict tenant without paying relocation? I think if you're asking, remember, you can't evict the tenant. I keep saying this, you cannot evict a tenant now unless you have just cause. If you have just cause, you don't have to pay relocation. But you can't evict them at all without just cause. What about the case of the seller who closes escrow and won't leave? And they say they got COVID or something. You can evict them. Failing to leave after close of escrow on a purchase contract that said you were going to leave on a certain date is absolutely just cause for evicting the tenant. I'm going to do one last question on this and I'll come back to these later. Melanie, What about just cause for the withdrawal of the unit from the market as just cause when selling property? I don't know how to answer this other than if you're taking the house off of the rental market, you can't terminate the lease, but when the lease is over, you can use the excuse that your lease is over and now I'm evicting you because I'm taking the property off of the rental market. And but that means, of course, you can't put it back on the rental market for 2 years. But yes, you could sell it as long as the buyer understands they cannot rent out this property for 2 years either. Okay, I think that's what you're getting at. All right, I'm going to come back. We're going to have time for more questions later. But let me talk about some other new stuff, okay? Those are the big, oh, by the way, one more thing here is there's a new rental form that all landlords need to know about. If you're a landlord and you have a tenant who's behind in their rent because of COVID, there is a new disclosure form you must give to the tenant. It's called the NTRA 2, the Notice of Tenant Relief Act 2. This is a mandatory disclosure form you must give to the tenant. Only if they're behind in their rent because of COVID. But if they are behind in their rent because of COVID and you don't give them this form, you're not going to be able to evict them in July. And you're not going to be able to sue them in July. But by the way, here's the good news I've finally been building up to. SB 91 also is enabling landlords to get rental assistance. Remember I just said that if the tenant hasn't been paying their rent, but as long as they've been paying 25%, come July, you can't evict them, but you can sue them for the back rent. Well, what if the tenant doesn't have any money? Or I don't want to wait till July. Well, federal money has been sent to Santa Clara County and every other county to compensate landlords for the back rent that the tenant owes them. So if you're a landlord, you're thinking, where do I get my hands on that money? Well, you go to this website called housingiskey.com. And all this is explained in our Q&A, housingiskey.com. And then you look up Santa Clara County and it will tell you how to apply to get this rental assistance money. The landlord, thank you, Jody. Yes, that's the website too. That's exactly the right place. Now, okay, so you want to get this money. The landlord and the tenant are both going to have to fill out an application. Some people say, what if the tenant won't cooperate? Well, you'd think they want to cooperate because if the landlord gets this money, then the tenant doesn't owe the landlord anymore. Anyway, so you look up Santa Clara County. It'll tell you how to fill out the application in that county. Now, there is a catch here. You're only going to be eligible to get this rental assistance if the household income of the tenants who owe you this back rent is less than 80% of the area median income. What does that mean? Area median income is defined by county. So let's say you got a tenant household of 4 people and they owe you back rent for COVID that they haven't been paying because of COVID. I want to see if I'm eligible for this rental assistance. Well, there's a link on our Q&A where you can go to, it'll take you to Santa Clara County median income for a family of 4. It actually says, it'll tell you what is the 80% number in Santa Clara County median income for a household of 4. So that'll tell you, okay, let's say in this county, the median income for a household of 4 is this amount, 80% of that is this amount, whatever that number is. If these tenants, if their current income, and they're going to fill out a form saying what their current income is, if their income is below that, you can get this rental assistance. And if you think about it, right, a lot of tenants who aren't paying rent because of COVID, they probably have low income, because if they had enough income, they'd be paying the rent. Anyway, but of course, they're going to be high-end properties where the tenants still have high income, but because of COVID, it's less than it was. But it's still more than 80% of the county median income, in which case the landlord's not going to be eligible to get this rental assistance. But let's assume that you, the landlord, your tenant is eligible, so you're eligible for this rental assistance. So you're going to say to Santa Clara County, great, I got this tenant. As you can see from the application, they owe me $20,000 of back rent. And since I'm eligible, please give me $20,000. And the county's going to say, well, you do qualify, so we're going to give you $16,000. And the landlord says, excuse me, I think I said 20, not 16. And the county's going to say, well, unfortunately, under California law, for us to give you this money, you have to agree to forgive 20% of the rent that's owed you. Landlord says, I don't want to forgive anything. I want every cent of back rent I am owed. Then the county's going to say, well, in that case, we're not giving you 80% of what's owed you. We're only going to give you 25% of what is owed you to cover the tenant's minimum. And then you can go ahead and sue the tenant for everything. But if you want more than 25%, you have to forgive 20% of the debt. And that's a decision each landlord's going to have to make. There are a lot of landlords out there. This money will run out, but the good news is more money is coming, because the 1.9 trillion bill that got signed, a couple weeks ago, is going to send more billions to California. So landlords who don't get paid this go around, I think will probably get paid next time. So you may have to apply more than once. I know landlords who've been gotten paid though, right? So it is happening. I don't know about Santa Clara County specifically, but I know it's happening. Okay. So that's the rental assistance. We see if there are questions on that specifically. Sandra, good question. You know about that Orange County case where the seller refused to leave for over a year? Actually, I think it was Riverside County. And the news report on that was misleading. It seemed to say, well, the seller was using the eviction moratorium as an excuse not to move. That's not true. As I just told you, sellers have to leave under contract. That's considered just cause. The eviction moratorium didn't protect them. What kept those sellers in the house was the courts are so backed up in Riverside County to do evictions that the buyer has just been struggling to get a court date to evict them. But the seller, they were not using the eviction moratorium to stay there. And guess what? Since all that publicity happened, the seller moved out of that, and the buyer has the house. So that's good. Sandra, that's a very general question. There are all sorts of rules on relocation assistance. I'm going to ask you to email me later or call the legal hotline. I can't really answer that generally. Jason, is there any legal basis for the seller verbally asking the buyers? I mean, there's no reason why you can't have a contract where the buyer agrees to buy the property with the tenants in there, and it's their issue, right? Doesn't have to be verbal. It can be in writing. Maria, what about landlords who continuously rent their properties for short term? None of these laws apply to short-term tenancies of less than a month, if that's what you're asking. Landlords can do whatever they want. Steve, SB 91 does not apply to commercial property, but San Francisco County might have their local law, which I'm pretty sure they have one, might apply to commercial. So you'd have to check with San Francisco. SB 91, the state law does not protect commercial tenants anymore. Okay. All right. Okay. Let's move on. We took all this time to talk about the big three: home hardening and defensible space, Prop 19, and eviction moratorium, and rental assistance. But there's other stuff happening, believe it or not. Speaking of assistance, let's talk about people who, it's not a tenant issue necessarily, but they're having problem paying their mortgage. Number one, anyone in California who has problem paying their mortgage because of COVID, the California lender has to give them, the lender in California has to give them forbearance. They have to allow them to delay making the mortgage payment now because they can't make it now because they have a COVID issue. How much forbearance are you entitled to? It depends on your situation. Sometimes it's 12 months, sometimes it can be all the way to the end of the mortgage. The payments are added on to the end. But what about some people who a year ago, they couldn't make their mortgage payments because of COVID? So those payments were delayed a year to about now. Now they can make their current payments, but it's going to be hard for them to make up these back payments that are now coming due. Well, the good news for these people is the federal government just announced about 3 days ago, and it looks like it's going to happen. There's going to be a foreclosure moratorium throughout the entire country all the way to December 31st for people behind on their mortgage because of COVID, even if they're no longer in forbearance. That still means they're going to have to pay the money back eventually. But speaking of that, good news is this 1.9 trillion bill is resulting in mortgage assistance money coming to California. Thank you, Jody, for informing me on the Santa Clara County. And remember what I just said, that foreclosure moratorium to December 31st. It hasn't happened yet. It just looks very, very likely. But anyway, this 1.9 trillion is going to result in mortgage assistance, not just rental assistance, but mortgage assistance coming to California to compensate certain property owners behind in their mortgage because of COVID. But we don't know the details because this program won't be rolled out until May 1st. And the federal government has supplied no details yet, but something's happening there. Okay. All right. Let's talk about some other stuff that has nothing to do with COVID. Homeowner associations. There's a new law this year, and Jody, I forget the bill number, sorry, that says if you have an HOA, if you live in an HOA, the HOA cannot prevent you from renting out your property. Well, let's rephrase that. They have to allow at least 25% of the people that own units or houses in the HOA to rent it out. Prior to this year, the HOA could have prohibited all rentals, or they only allow 10% or 20. Now they have to allow at least 25%. And they can't put unreasonable restrictions on who you can rent to. They can't say, oh, you can only rent to single people, or you can only rent to seniors. I mean, if it's a 55, you're right, it is 3182. Jody, you know these better than me. Thank you.
No, Google. Thanks, Google.
Okay, great. Anyway, so, you know, if it's a senior complex, yeah, the HOA could say you can only rent to people over 55. But if it's not a senior complex, they couldn't say that, or they couldn't say single people only. They could say, no more than two per bedroom, 2+1 per bedroom, 2-bedroom house, only 6 people. They can, HOA can put some restrictions on who you rent to, but they can't just have these arbitrary ones. And they have to allow 25% to rent. And you know what? If you just want to rent out your garage, or you want to rent out your back unit, but you're still going to live in the main part, HOAs have to allow 100% of those to be rented. They can't restrict those. Okay. So you have more rights with respect to renting properties in an HOA. That's a new law. There's another new law. Good luck finding this one on Google, but try, Jody. There's a new law that says when you foreclose on a tenant-occupied property, the tenant has a first right of refusal. So imagine this. Foreclosures are happening. There's a foreclosure. So you go to the auction. You see the nice house you want to foreclose. So you win the auction. Normally, prior to this year, I would have said, great, you foreclosed. It's now your house. And that's still true if you're going to live there. So if you foreclose on this residential property and you intend to live in this house you just foreclosed on, as soon as the sale is, the auction is done, it's your house. But let's say you're right, Jody, you did it again, SB 1079. Way to go, Jody. Under this law, okay, so you guys are lucky you have Jody. Anyway, so let's say I'm an investor. So I want to foreclose on this property, but I'm not going to live there. But there's a tenant there. After the auction happens, the tenant has 15 days to notify the trustee that they intend to try to buy this property. And if they notify the trustee within 15 days, then they have a total of 45 days, starting from the auction, to actually make the deal, close the sale at the same price that was the winning bid at the auction. Okay? So what this means is if you foreclose on this tenant-occupied property, you don't know for 45 days whether it's really yours. 45 days from now, the tenant may successfully buy it at the same price that you won the auction at, because you're an investor who doesn't plan to live there. Now that leads to a question. So I foreclose on this tenant-occupied property. I don't know if the tenant's going to buy me out or not, but do I now have responsibility to take care of the property that I just foreclosed on? Apparently, yes. Does that seem fair? That you have the obligation to put up money to take care of this property, even though in 45 days from now, the tenant may actually buy it from you. And they're not buying it from you, you're buying it from the trustee. For that reason, some people think this law is just not enforceable. It's not legal. It's not constitutional. So this law may not survive, but it is a law. And you know what else it says? It says, even if there's no tenant on this property, if an investor forecloses on a residential property and anybody in California, not just a tenant, anyone in California who signs an affidavit saying, I swear I will, if I get this house, I will live there, they have 15 days after the auction to submit a bid that's got to be higher than the winning bid at the auction. If they submit this bid and it's higher than that, the highest bid wins, and they have 45 days to buy the house, in which case, after 45 days, If they come up with the money, they buy the house. So what this really means is if you're an investor foreclosing on residential property, but you don't plan, so you're an investor, you're not going to live there, you don't really know if it's yours for 45 days. Like I said, I'm not so sure this is going to survive, but right now it's the law. All right. By the way, getting back to forms. So what have I told you about forms so far? Well, I've told you that you still got to use the COVID eviction forms. They're not new. They've been tweaked a little bit, but they're not new. I've also told you for now, you still got to use the PED form and the posted rules of entry. Then I told you there's a new disclosure form, the HHDA, which is going to be tweaked at the end of June to cover defensible space also. And then I told you that there's this new NTRA 2, where you are basically have to disclose to the tenant what their rights are under the eviction law. So you're going to ask me, are there any other forms, new forms that I need to know about? And the answer is there's just one, which you're already probably seen, but I just want to talk about it for a second. That's the Fair Housing Advisory, right? The Fair Housing Advisory. That's not a form required by law, but it is attached to the purchase contract. It's attached to the listing. It's attached to the lease form, buyer broker form. And the reason it's attached is sort of tell you, you might want to get your clients to sign this. Why do I want my clients to sign this? Because you don't want them coming back later and saying, well, you didn't tell me I couldn't do that. It's your job to tell me what I can do and can't do under fair housing. And they may be right. So you give them the form and they sign it. They can't come back and say, you never told me what the new fair housing rules are. So the next question is, what are the new fair housing laws that they should be aware of and I should be aware of? Well, this form, you probably looked at it. It explains a couple of things. It explains what the fair housing laws are, who has to comply. It gives examples of things you shouldn't do. One thing you shouldn't do, of course, is steering. I think we all know that you shouldn't only show someone properties in a particular area based on their personal characteristics. But what if your client comes to you and says, listen, I'm looking for a quiet neighborhood without kids. Could you please only show me properties in quiet neighborhoods without kids? In other words, the client is asking you to be steered. You still don't do it. You say, listen, I don't identify properties, families, neighborhoods with kids, with not kids. So I'm going to show you everything in your price range. Well, what if the client says, I'm looking for a Russian neighborhood. You know any places where there's a lot of Russian people? Same thing. Even if you happen to know where the Russian people live, or the Polish people, or the French people, or whatever, you don't help them with that. But if they say to you, yeah, I want to live, east of the 101 freeway and north of Main Street and south of Elm Street and west of First Avenue. I'm just making stuff up. If they define their geographic area, then only show them properties in that area. But don't be the one to steer them to particular types of properties. The other thing is, California has recently expanded the categories of people you can't discriminate against in real estate. Did you know nationwide, under federal law, you're not allowed to discriminate based on race, religion, color of skin, country of birth, age, gender, disability. But under federal law, you are allowed to discriminate in housing based on sexual orientation, based on gender identity, based on whether they have kids or not, based on whether they're married or not, based on what they do for a living, based on citizenship, based on immigration. None of that is true in California, though. California has 22 protected classes as opposed to 7 under federal law. So this form reminds everybody, some sellers think, well, I can sell to whoever I want. If I don't want to sell to a gay person, I don't have to sell to them. That's true in a lot of places. That is not true in California. California, you can't refuse to sell to someone based on any of these characteristics. So this is a good reminder to everyone of that. And also there's something on this form you might have noticed, paragraph 8. It discusses the issue of buyer letters. If you think about it, I know in a hot market like we're in now, buyers will submit offers, but they won't just submit an offer. They want to submit a letter about themselves to the seller, to, saying to the seller, pick me as opposed to everybody else. I'm different. I want you to know about me personally to help you make your decision on selling to me. So they write a letter like, yeah, my husband and I and our 3 kids, we just moved here from Germany, and this is a perfect house for us. You've taken such good care of it. It's so beautiful. We will honor your memory and we'll take care of it good too. My husband can open his dental practice here. I can open my architect practice here. So please sell me this beautiful house. You've just told the seller your marital status, your family status, where you're from, what you do for a living. These are all, and then they include a picture which shows their ethnic background. These are things that if I were the seller, I don't want to know. Because if I know this stuff about the buyers, I can be accused later of bias. Oh, I know why you didn't sell me the house, because you don't like families with children. Or you don't like single people and you sold to the family with children. Or you don't like dentists, or you don't like people from Germany. Whereas if I don't know this information, nobody can accuse me of bias. You see what I'm saying? So that's why this form sort of tries to discourage the idea of these letters. Are these letters illegal? No. If the seller says, I understand what you're saying, but I still want the letter, they still want to take the risk of being accused of bias, you can't stop them. If the letter comes in and they want to see it, you got to give it to them. But I think the thinking is it's probably not a good idea, these letters, unless the letter is just talking about the house and not talking about the personal background of the buyers. I think you'll understand what I'm talking about here. So that's a new form. That's an important form. Not required by law, but it's in your interest to give it to your clients and have them sign it, right? Let's talk about a couple more things. There's probably going to be a couple of tweaks to the listing form. Why do I say probably? Because there are a couple of issues like coming soon. Did you know different areas define coming soon differently? But there's a movement to try to get uniformity, where coming soon would mean the same thing everywhere. And when that happens, there'll probably be something on the listing contract specifically talking about coming soon. Or you know what else? Do you know there's a new rule that the listing agent has to disclose in the public part of the MLS how much commission is being paid to the buyer's agents? Now, this isn't required nationwide yet, but I think some MLSs have already imposed that. And I don't know, you guys can tell me if you want, if your MLS already requires that. But once it's required everywhere, I'm sure there'll be a change to the listing contract to clarify that whole issue of disclosing how much commission is being offered to the buyer's side, right? Let me go to questions real quick. Yes, Margaret, the investor would get a refund from the trustee. Diana, what can you do to make your offer stand out? Well, you can write a letter and talk about the buyer's financial qualifications. You can flatter the seller about how great their house is. just don't include buyers' personal characteristics. I know it's so horrible and hard in this market now for the buyers to try to make themselves stand out. But you just got to be careful, is what I'm saying. I'm sorry, AB 30, within that 25% limit, short-term rentals. Yeah, short-term rentals, HOAs can absolutely prohibit short-term rentals, Airbnbs. They can just absolutely say no, okay? Sandra, PRDS has a form. Why won't CAR create a form where the seller opts out? Good point. I'll suggest that to the forms committee. Very good point. Mary, are we required to present those love letters? Well, you have to have the discussion. If you're the listing agent, you have this discussion with your seller, right? So if you and the seller agree that these letters are a bad idea, then the seller has basically already told you, don't present them. But if you have this discussion with your seller and you tell them to read paragraph 8, but the seller says, I still want the letters, then you give them the letters. It's still their right, right? Okay. Jackie, thanks for updating me. I think your MLS is already has that field about disclosing the commission to the buyer's agent. Like I said, we're probably going to get some changes. In other words, I think end of June, which I'm not going to see you before then, there are going to be a couple of changes to the listing form. So they're not going to be a new form, but they're going to be changed, right? I try to give you a forms update. So the only new forms right now, I've already told you about. The home hardening is going to be tweaked. The fair housing form, which is the FHDA, Fair Housing Disclosure and Advisory, and then that NTRA 2. Other than that, I don't think there are going to be any other new forms right away. Things can always change at the last minute. And you know, of course, if all these laws change on COVID, maybe there won't be a PED form anymore, or maybe the PED form is going to be different. You know what I'm saying? Hopefully it'll just go away, but you never know with COVID. And if they change the rental laws again, if they extend the rental laws past July 1st, we'll definitely have to tweak all of the eviction, the COVID eviction forms too. All right. Couple more things I want to talk about. I think we're done with forms. Some common questions we're getting in this market about multiple offers. Couple of issues. Can I make it my offer? My offer is 5,000 more than the next best offer. Is that legal? Yes, that's legal. The risk of doing that, of course, is if you make a non-contingent offer that's 5,000 more than the next best offer, and somebody else offers like 300,000 over the fair market value, your offer is now 5,000 more than that, and the seller can accept your offer. And since you have no contingencies to get out of the deal, if you don't buy it, they keep your deposit. So that's a risk. So you might want to put a cap on your 5,000 above the next best offer, not to exceed whatever. But of course, that just tells the seller how high you're willing to go anyway. So anyway, the point is it is legal. But you know what? Another risk is, what if two different buyers on the same listing each make an offer? My offer is X amount more than the next best offer. Well, guess what? Courts are going to say both those two offers cancel each other out, and neither one is valid, right? So there's risk in doing it. Here's a question we get, or an issue. I just remember, when you submit an offer, even though there are 40 offers on this listing, and you follow up with an email, the listing agent must inform you exactly when your offer was presented. Or they can say something like, my seller told me don't present any offers under 700,000. Or my seller said, wait till Saturday, present all offers on Saturday. But they have to tell you what's going on. And if they tell you we're going to wait till Saturday, you can call them up on, you can ask them on Saturday, what happened to my, in other words, listing agents must tell you what happened to your offer. They must present it. And they must tell you when they presented it, unless the seller didn't want it presented. Okay? That's one issue that comes up. Do they have to prove that they presented it? Well, I don't even know how you prove that. How do you prove an offer was presented unless you take a video of yourself presenting it, right? So they don't really have to prove it. But you know, if they say the offer was presented on Thursday at 5 o'clock, there's nothing stopping your buyer from calling up the seller and say, did they really present my offer at Thursday at 5 o'clock? I mean, buyers are allowed to contact sellers, right? Okay. Another issue that comes up is buyer says, I'm sorry, the buyer's agent calls up the listing agent, says, how many other offers do you have any other offers yet? How many do you have? How many offers do you currently have on this listing? Does the listing agent have to answer that question? No. They can say, no, my seller and I have decided not to answer that question. But if the listing agent chooses to answer the question, then they have to give a complete specific answer. In other words, they can't just say, yep, we got a lot of offers. They'd have to say, yes, we have 14 other offers. And they also have to disclose, and 3 of them are from my buyers or our office buyers. So they have to disclose how many, and any of them are in-house. Or they don't have to answer the question at all. Just, I'm not going to answer. So then what are the buyer's agents? How much are the other offers that you got? Or how much is the highest offer you got? Does the listing agent have to answer that question? No. Can the listing agent answer that question if they want to? Yes, with the seller's permission. Okay. So this keeps coming up a lot. You know what else keeps coming up a lot is buyers, you know, there's a problem with appraisals. Appraisals aren't catching up to the prices. So the buyer writes an offer. My offer is 30,000 more than the appraised value. Problem with that is it doesn't say whose appraisal. And sometimes the seller doesn't understand that if they accept that and the appraised value is a lot lower than what it's really worth, the seller has to reduce the sales price down to that appraised value. And I'm sure that's not what the seller thinks they were agreeing to. Or sometimes the buyer's doing that and they're just basically trying to say that my contingency is, normally my contingency is based on the property appraising, but what I'm saying now is, even if it doesn't appraise at the purchase price, as long as it's not more than 20,000 over the purchase price, I'll make up the difference or something like that. The point is, people use these words without really figuring out what they really mean by these words. So what we're telling people is, your buyer wants to get that creative, they should probably hire a lawyer to draft an addendum. And by the way, speaking on what I've just been saying, we have a couple things on our website. We have Q&As on our website. We also have something called quick guides. You just have to search quick guides. We have a quick guide on these escalation clauses that I was just talking about. You know, the 5,000 more than next best offer. We also have quick guide on the appraisal contingency language, like I just said. We have a quick guide on that home hardening law. We got all sorts of good stuff there. So these are the types of questions we've been getting in this market, this crazy market. Are there anything else I really think you need to know about today? You've listened to me for a long time. Maybe give you one more bit of good news. Thank you, Jody. You guys are very lucky to have Jody. You know, most times when I do this, I don't have a Jody helping me, and she's very good. Give Jody a raise. Okay. Anyway, Jody, you're going to find one more law for me, and that is there's a law that has increased the homestead protection that all of us California property owners have. What does that mean? Okay. I'm going to get your questions in a second. Yes, Sandra, I did talk. That's what I meant by escalation clauses. Diana, buyers are able to contact sellers. Interesting, right? I know what you're thinking, and you're right. If your buyer contacts their seller, the listing agent's going to have a heart attack and be so angry at you because they're going to say, you got your buyer you made your buyer to do this. So I'm not saying it's a great idea to do it. I'm just saying there's another legally preventing a buyer from contacting a seller directly. Of course, this may get the seller listing agent so angry that you're going to lose all chance of getting the who knows? I'm just saying. And Diana, how do your agents find out what the highest offer has been at this point? There is no way. If the listing agent doesn't tell you, they don't tell you. Sandra, what about buyers canceling prior to earnest money deposit? I think what you're asking me is buyer writes a contract, but before they even put money into escrow, they change. They change their mind, right? Well, as a practical matter, they signed a contract. They don't really have the right to cancel. But if they didn't put their deposit into escrow, they don't have much of a risk, do they? Because they don't have any money there at risk. Now, can the seller say, oh, you breached the contract by not performing, even though you didn't put the deposit in escrow? I'm going to sue you for the amount of deposit you should have put in escrow. So you can, because you owe me that money. You know, I've never seen a seller do that. And I'd be interested to know what happens if they did try that. Interesting, right? Julie, when listing a home, is there an amount of time required it to be on the MLS? No, there really isn't. And this is what gets people very upset. You know, it's on the MLS, and then 5 seconds later, it's pending. That doesn't seem right, does it? I mean, isn't the whole idea of putting it on the MLS to put the word out there to enable any buyer out there who wants to have a chance on getting this property, put an offer in? I mean, if we accept, I mean, if it's hard to imagine to me that the listing agent is doing their job if they let the seller accept an offer 5 minutes after it went on the MLS without seeing all the other offers. But that's just me. Margaret, good question. Getting back to this no deposit and escrow thing. So if the buyer, if you're asking on the seller's side, right? Are you asking on the seller's side what you have to do to terminate the deal or what the buyer has to do? I mean, if there's no deposit in escrow and on the seller's side, you want to just cancel the deal. Are you saying because the buyer is okay with it being canceled? I mean, obviously the seller can't just, are you canceling because they didn't put their deposit in? Sorry to keep asking all these questions, but I'm trying to get at what you're really trying to do here. I mean, if the buyer hasn't put their money into, maybe this is the issue. If the buyer hasn't put their money in escrow, but they still think they want to buy the house, you can cancel them without their permission. In other words, there's a form called the cancellation of contract, CC, but if there's no deposit in escrow, the seller can just sign it, deliver it to the buyer, the deal is over. Buyer can't do anything. Once they've put their deposit in escrow, you can't cancel it without the buyer's permission. And if you try to cancel without their permission, they can put a lis pendens on the property and prevent you from selling it to the next buyer. But if you have a buyer, no deposit in escrow, but they're in breach of contract, so you want to cancel them from the seller's side, you can just send them the CC, cancellation of contract, doesn't require the buyer's signature. As soon as you sent it to the buyer's agent, the deal is over. So, okay, thank you. Sandra. Yeah, that's what I'm sort of speculating here. You know, buyer cancels without putting money into escrow, and seller is harmed by this because when they put it back on the market, they can't get the same amount. Of course, I'm thinking in this market, they probably are going to get the same amount, but let's say they can't. So they've been harmed. That means they've been harmed by the buyer who breached the contract. Now, the purchase contract says if you sign liquidated damages, your damages you can get from the buyer is limited to the deposit. But what if there is no deposit? Can I still sue the buyer? And that was the issue that I was saying. I want to, there needs to be a test case. Someone needs to try that. I haven't heard of that actually happening, where the seller can successfully sue the buyer for, I don't see why they shouldn't be able to though, right? Now I see what you're saying, yes. You do have to send them a notice to perform first. Yes, sorry, that was part of your question, or Margaret's, I forget who's asking what anymore. But anyway, yes, you're right, I should have said that first. Notice to perform before the cancellation, even if there's no deposit. Right, good point. Suzanne, I think I said differently, because you do not have to pay relocation to a tenant if you're evicting them because you have a buyer who has a signed contract to buy the house and you're going to move in. Unless, like you're in LA, where the LA has a local law that requires certain relocation. In LA, you can't even evict someone for that reason, but some local rent control laws have their own eviction, relocation requirements. I'm just talking about California law. So under California law, Suzanne, no, you wouldn't have to compensate the tenant if you're evicting them in order to sell the house. Okay, assuming you have the right to do it. Okay, great. All right, the last thing, Jody is, this is how great Jody is. She already came up with it. I'm going to hire Jody, just kidding. SB 1885. Here's the good news to end on today. Every one of us who owns a house, owns a residence in California, we have greater protection against foreclosure from unsecured creditors. A homestead means that if somebody sues you, you know, business, car accidents, they sue you, right? And they get a judgment against you. They can use that judgment to take your house away from you if the judgment is high enough to pay you your homestead and to pay off any secured loans you have. Last year, the homestead amount in California depended on who you were. It depended on, if you were single, you had a $75,000 homestead. If you were head of a household, you had 100,000. If you were over 65, you had 175. Let's take me last year. Me last year, LA County, doesn't matter where I was, I have a homestead of 100,000. So let's say I owe my lender 100,000 and I have a homestead of 100,000. Someone sued me last year for 400,000 and they got a judgment. They could take my house. They could foreclose on my house, pay me my $100,000 homestead, pay off my $100,000 loan, and that's it. They get the rest. If they tried that this year, they couldn't do it. You know why? Because my homestead has gone from 100,000 to 600,000. Every one of us who owns a primary residence, our homestead is now gone from 7,500 or 175 to 600. But let me be precise. Your homestead now is, and it doesn't matter if you're single, household, senior, it doesn't matter. Everyone, your homestead amount is 600,000 or the median sales price of a single family home in your county the previous year. So I'm going to assume that the median sales price in Santa Clara County last year was over 600. If that's true,